Um, but the reason why it's important for this talk today is that the New York Trust Code, as it's drafted and as it's being proposed, does include laws authorizing settlors, grantors, to direct the non-disclosure of the existence of a trust, at least for some period of time, unless a trust document states otherwise, to solely the qualified beneficiaries of the trust. Qualified beneficiaries, it's a defined term, and it includes the current beneficiary or presumptive remainder beneficiary of a trust. So these are the individuals who would have an interest if the current income beneficiary interest ended right then and there. You look at it at that moment in time, and that's how you determine who those qualified beneficiaries are. And how it works is the New York Trust Code requires the trustee to inform and furnish any requested information about an irrevocable trust to these qualified beneficiaries who are over the age of 25 after the death of the survivor of the settlor and the settlor's spouse, or 21 years if the settlor is an entity and not an individual. Okay, so basically it appears that if the grantor and their spouse are still alive, then there's no age at which a qualified beneficiary must receive information about a trust. And also, even if you have the grantor and the grantor's spouse who have passed and they're dead, the trust can still remain quiet until the beneficiary reaches the age of 25. When we all become adults and are responsible and are no longer the crazy 18-year-olds that we once were. But in some cases, this delayed disclosure, it may be enough to accomplish the client's goals and what they're looking to do. But we still have those same provisions in the New York Trust Code that says a trustee has to send annual statements to any beneficiary who requests them, regardless of whether they are a qualified beneficiary or not. So if any beneficiary becomes aware of the quiet trust, if you've got, loose lips, sinking ships, then what's going to happen is that then the trustee has to provide the information that's being requested. Again, New York Trust Code, it remains a proposal, but practitioners really should be aware that this is something that's coming down the pike. Hopefully, we're all really hopeful.
And it's probably likely.
Yes.
It's hope. We say hopefully, but the reality is, I'd say it's more likely than not that New York's trust law will be turned on its head within the next year or two. So this is kind of part of why we wanted to give this talk today. Until that happens, until New York law changes, what are some of the practical considerations, that we can consider when clients come to us, asking for a quiet trust, or conversely, when the trust already exists and they come to you to administer it, or have questions about the administration, or to litigate it. So we'll divide this consideration into two steps. First, let's look at the drafting stage, and then we'll look at, assuming the trust has already been created, what do we do with it? So you're sitting down with clients, whether you're a financial planner or a lawyer or even an accountant, because most of the time it's the accountant who is really, in the thick of things before the lawyer is. And the client, says that for tax reasons, we want to create this trust, but we don't want our kid to know about it or our grandkids. Well, the first thing I think you need to do is educate your clients. Don't assume that a quiet trust makes sense. Don't assume that it's actually best for the beneficiary to not know about the trust. I think you need to challenge your clients on that. And I challenge not because you have a better answer, because I think it's about the process. It's about the thought process that goes into this. Because I've found that oftentimes clients come in asking for something. I need a this or I need a that. And I say, why? And then when I find out the answer, sometimes it's apparent that what you were asking for is actually not how you accomplish your goal. You should be looking at this instead of that. Okay. So, why don't they want their kids to find out about the trust? Given that these legal issues under current New York law exist, is it really worth it? Is ignorance really bliss? That's really the fundamental question. We all want our kids to thrive. We want them to be responsible. I think it's incumbent upon us to at least pose the question. If we want to be real, good, trusted advisors, pose the question, might it be better to explain to the child or the adult child that, look, there is this money here, but you need to learn how to be responsible in dealing with the money. You need to learn how to be a good steward of this money. Now, of course, there is not always a right and a wrong answer, and the answer isn't always clear. Let's assume, for argument's sake, the client has thought this through properly and concluded, for whatever reason, under those circumstances, a quiet trust makes sense. Well, you then have to consider, what specifically is the client asking for? What level of quietness is the client asking for? So, for example, if the client is saying, I want you to draft me a trust that says, under no circumstances may the trustee, give any information about the assets of the trust to the kid, or even acknowledge its existence when asked. Okay, clearly that, as Jennifer said, is not enforceable under New York law and under any state's law. That's just void against public policy. That truly
perjury
attacks the integrity of a trust. Remember, I said that common denominator is disclosure, and you got to keep the trustee honest. I mean, that is just not acceptable. Okay, if they start asking, well, maybe we'll delay it into a certain age. Okay, now we're talking. Okay, maybe we can have that conversation. But Jennifer, let me turn it back to you and ask you: is there anything else that we can do under current New York law to try to get some of the benefits of a quiet trust in New York?
Okay, so I think that one of the things that we need to be thinking about, and that practitioners should already consider including in their trust documents, relates to virtual representation. Okay, so virtual representation, it's typically used in court proceedings to kind of streamline the process. So you can get jurisdiction over members of a class, which may vest at a future time. So essentially, if there's a person who can represent a beneficiary's interest, you may be able to avoid providing notice to the beneficiary. In determining whether virtual representation applies, the courts, they consider, are the economic interests of the representor and the representee similar? If there is any conflict of interest between the two, do they have the same interest, or are their interests slightly divergent? And whether the representee would be adequately represented. This can be particularly helpful, when you have a person under a disability and they have the same interest as someone else that's in the proceeding. This is known as horizontal representation. And because the representor can represent the interests of the person on the same level. To use horizontal representation, though, you have to make sure that the trust explicitly says that you can use it and that it's in the actual document. So let's think about it like this. Let's consider an accounting proceeding. Okay, so an accounting proceeding is where the trustee has put forward an accounting, a document of everything that they've done over a period of time. Let's say in this particular accounting, we're dealing with a trust where the trust remainder is left to the decedent's grandchildren. Now, since the grandchildren all have the same interest in the proceeding, process would have to issue to each of them. But if at the time of the accounting, there are one or more grandchildren who are under the age of 18, or they're otherwise under a disability, you'll probably have to have a guardian ad litem appointed to represent those interests. We all love our guardian ad litems. I've been a guardian ad litem. Everyone loves guardian ad litems. They're there to protect the interests of, their wards. But of course, we know that it can cause delay. It can cause an additional expense. And when you are the person who is, counseling a client when it comes to the drafting stage, you need to be thinking about these things to help streamline the process to get to what they want and where they want it to go. So if you have an instrument that has this horizontal virtual representation, and there's at least one grandchild who is an adult and competent, there's no need to serve process, or you can at least make the request to the court that there's no reason to serve process on all the parties under a disability, because their interests can be represented by that adult competent grandchild, unless the grandchild's interests are different, or the court for some other reason finds that would be inadequate for that to happen. But I caution all of you, because if the court later finds that virtual representation didn't exist or it wasn't appropriate, then jurisdiction wasn't complete and the decree can be vacated. So now you've opened up that court proceeding again, because it's always important, and it's like tantamount, that the court has jurisdiction over everyone so that they're able to come in and protect their interests, or that everyone's interests are in some way protected, be it through a guardian ad litem or otherwise. Now, there are some states, in fact, Delaware is one of the states, where a designated representative can receive disclosure of trust information on behalf of the beneficiary and hold the trustee accountable. Essentially, they just step into their shoes. This individual can be named in the trust, or they can be appointed by the court. Now, while there's no statute in New York that allows for a designated representative, and that's also not a concept that that's going to be utilized under the New York Trust Code, we're going to talk about that a little later, you may want to consider putting in your documents language that designates, for example, the parents of a minor as being a legal representative of their minor children. A trustee may be able to get a release from those legal representatives if there's a designation of this in the trust document, and the parents execute a release on behalf of their children, and most importantly, agree to indemnify and hold harmless the trustee for any actions or any releases that they have provided. This does provide some protection to the trustee while still not making a disclosure to the beneficiary. Essentially, the parents have come in, they've taken on the burden. And of course, whenever you're dealing with an indemnity, it's never perfect. But, you know, sometimes we run into these situations where we're trying to come up with the best way to figure out how to get our client's interests represented. I think we're back to you. Mm-hmm.
Sorry.
I stole his notes.
So, you know, another thing, practical consideration that we could think about before New York law changes, really goes back to commissions, relates to commissions, something Jennifer spoke about before. And just to reiterate what she said already, there are certain statutes, SCAPA 2306 and 2309, that require a trustee to provide annual statements, summaries of information, basically, about the trust when the trustee takes annual commissions. And so what can we do? Obviously, that lets the cat out of the bag if the trustee is giving the statements or this information about the trust. And by the way, what is in that information? It's the, you know, how much income was collected that year, you know, expenses, the value of the trust, et cetera. So one little trick to think about is, you know, and it's buried, and this comes from, it's buried, I think, one of the last provisions in SCAPA 2309. It says something to the effect of, if the trust specifies the exact commissions that is going to be given to the trustee, that is, it's not the formulaic commissions provided for in 2309. If it says like a certain dollar amount, he gets $50,000 a year, for example. In that case, the trustee does not have to give the annual disclosure. I mean, on the face of the statute, it says it's just not necessary. Okay. You know, that's one way to sort of not let the cat out of the bag. The battery's running low on this computer. I don't know. Oh, okay. Okay. Another thing to think about is a trust protector. Now, again, it's not statutorily defined in New York law. It's one of the reasons why we're kind of behind. We are behind. But so trust protector is this amorphous, not defined. You know, you can kind of make it whatever you want it to be. So you might say, I'm going to empower a certain person to almost act like a policeman, okay? And maybe give him the power, this trust protector, the power to remove and replace the trustee if the trustee is not doing a good job. So again, try to avoid going to court, the need to go to court. And if the grantor is, passed away, someone is able to look out for this trust other than the beneficiaries, okay? So that's something to consider. But frankly, probably the best thing to consider, or it should be considered, is unfortunately creating the trust outside of New York in another jurisdiction. And I've done that, frankly, I've done that a whole bunch of times over the last few years. I work with counsel in other states, and we create the trust that way. Now, Delaware is a state that I tend to work, a fair amount with. And I think in our materials, there's actually something from ACTEC that goes through all of the various states, or at least the states that have quiet trust laws, and you can sort of get an overview of that. I think that is unfortunately what you have to do. So Jen, under the existing, quiet trust situation in New York, when we're talking about practical considerations, that's the end of the drafting stage. Now let's assume the trust exists. We have a trust that is purports to be a quiet trust in New York. Someone comes to you either in the administration phase or in the litigation phase. Can you tell us, anything from that perspective?
Oh, Joe, it's going to come down to being what everyone's favorite attorney line is, which is, it depends. Because that's the truth of the matter. The truth of the matter is you have to look at every specific situation specifically. It needs to be a very specific fact-based analysis of what's happening here. What are the ages of the individuals? What was the ages when the trust was drafted? Is the grantor alive? So I think that there's a lot of different facets that come into it. And it really just encompasses all the things that we've talked about here today. But I do think we have a couple hypos that we want to kind of throw out at you. Okay, so let's say a client comes to you and they want to create a trust, but they don't want their kids to know about it while they're alive. So, because not only is he treating his children differently, he also has a secret love child that he plans to include in his planning. And he feels really badly that he didn't acknowledge this child while he was alive. So he's going to give this child more under this trust after he dies. So the question is, can you draft this? And
Well, you can draft anything you want. Yeah. Now, in this example, the good news is it sounds like a testamentary trust. So the grantor is not going to be around to see the damage that he causes in the relationship. But I don't see any problem there, because we do have the freedom of testation, and New York law, no other state requires, I don't know about that, but there's no forced heirship here. Okay. So you can disinherit people and that's fine. But there's nothing about, and this is a revocable trust. So certainly while the trust while the grantor is alive, there's absolutely no problem with any of this. Where the problem starts to come in is when you have beneficiaries and the trustee is prohibited from giving information, but simply not treating them equally I don't see as a problem.
And not letting anyone know until you're gone that it's going to happen. That's
No.
Also not a problem. Okay, so hypo number 2. Not as fun as that one. A wealthy older couple is doing planning, and you're making some very fabulous suggestions to them about
Hold on, technical difficulties. Stand by.
Peter, I think you're on mute.
Unmuted and video on.
Okay.
Hold on one sec. We're basically there.
You're basically
We
there.
You
can
have to do
see
this,
you.
Peter, or no?
Thank you, technology.
Yeah, we could see you guys fine.
Okay,
Okay,
good.
all right.
Okay. And you can hear us too?
Yep, nope, yep,
Okay,
perfect.
great. Okay, so I'll start hypo number 2
I
again.
think we're back. We're back
Okay.
on the big screen.
Okay. So we have a
Well,
wealthy,
people-
oh, now we gotta turn it off. Feedback.
Need a backup plan.
Okay, we have a wealthy older couple who's doing planning. You're making some very fabulous suggestions about brats, slats, etc. But
We
they've also
can't see
shared-
you guys at all.
Okay, we got it.
Can you hear us now?
Now we can see you. Okay.
Can you hear us?
Yep, we hear you and see you. Thank you.
Thanks for giving us the nuclear code.
I'm sorry, but you need to be here in person to have heard all of the very, very secret information that we gave while you guys were off. But regardless, we have a wealthy older couple. They're doing planning. You're making some really great suggestions to them about things that they can put together. But they've also shared with you that they have an 18-year-old grandson who's pretty wild, and they're concerned that he's not going to apply himself if he knows about the trust. They don't want him to even know that the trust exists until he's 25. So there are potentially some things that can be done in this situation, right?
Yeah,
Joe?
that's something that doesn't shock the conscience. It doesn't offend the conscience. And you know, because you know, there's a stated age, although that age is nowhere to be found in current New York law. And we're assuming it is current New York law. And I think that this is probably a very common fact pattern. I think there are, in fact, a lot of quiet trusts in New York, but under the radar screen. So you have trusts created for beneficiaries, and everyone, the adults are sort of in on it. You know, you just keep your mouth shut. You don't tell them about it. And, you know, even if annual statements are being mailed to the child, okay, guess who collects the mail? Mom or dad, okay, collects the mail. So the child is not, you know, practically not aware. So I technically, if this were litigated, it goes back to that same issue. Well, did the trustee, which was not part of the fact pattern, but did the trustee refuse to give information when asked by this 24-year-old? Okay, that's definitely not acceptable. But you know, if you just kept it quiet, because you know, there's no real duty that's articulated right now to go out, at least in the current New York law, and go, you know, knock on the door and talk individually to every beneficiary and say, hey, there is a trust for your benefit. Here's a copy of it. Okay, no, that's not how it works. So practically, I think that's okay.
I think we can also probably work into some of the other things that we've talked about by like having the parents name the legal representative in the documents. And then if there's some kind of indemnification that the parents give back to the child, to the trustee, you know, I think that there's some workarounds. And again, you're right. It doesn't shock the conscience to keep it for a certain period of time.
The point that I think Jen made before, I want to reiterate, you know, it's one thing I've been focusing myself today on, does the trustee have a duty to make disclosure? But you know, I think Jen's focused a little bit more on the practical. Well, let's assume for argument's sake that in that hypo, there's no problem there that with the trustee not going out and telling the beneficiary himself, the 24-year-old. But then, but that doesn't mean the trustee gets released from liability. So would a trustee be willing to do that if he doesn't get released from liability? And that's where the indemnities come in.
Right. Okay. So we touched a little bit on this, but now we have the third hypo, which is a client comes to you, they're very private, extremely cautious. They indicate that they don't want the beneficiaries to even know that a trust exists because they're worried that the beneficiary is going to hide their heart meds and then they're going to be, you know, that is speed up their demise. And he wants to put something in the trust that prohibits the trustee from mentioning the trust existence to the beneficiaries. And if asked, that they have to lie and deny its existence until he's dead.
Okay.
I'm going to take this one first.
Okay,
because
thank you.
I think there's some other issues here that we need to deal with. First of all, is it true that he really, you know, maybe, you know, the victim of elder abuse, which is certainly something that we always need to be keeping out. You got to ask some more questions. And then the second issue is, are there capacity issues and can you even draft this trust? So let's
Spoken like a true litigator.
putting those aside.
Putting those aside, this is the fact pattern I already
Yeah.
gave. So this is not enforceable. So you need to have a real heart to heart with the client. So that said, I think we're at the point now where we're happy to answer any questions online or in person. I don't know how we
You can use the chat box. I can
use
see
the
it.
chat
I
box.
think the third part is why would you give some money to somebody that you think's gonna kill you?
Well, that's a very good question.
That's a very,
too.
see, now you're coming at it from a practical
There you
perspective.
go. That's what we do.
If anyone on Zoom has a question, you can put it into chat and I can read it.
Yes.
I know you talked a lot about the age of the beneficiary.
Okay, we have a question here. We'll repeat it. Go ahead.
You talked a lot about the age of the beneficiary and when that affects the analysis. I'm kind of hung up on that. Suppose a 14-year-old hears from a friend at school, hey, I saw your family on the Forbes list, and you're probably going to be coming into some big money at some point. And this enterprising 14-year-old, sees mail laying around from City National Bank, picks up the phone and says, hey, I think I've got a trust for my benefit at your bank, and I want to know more about it. Are they entitled to the information?
Well, they're a minor, so
Wait, we got to repeat the question.
Oh.
So the question is, what happens if you have a 14-year-old beneficiary of a trust and the family, in this case, is on the Forbes 100 list? So they're, very, very wealthy and prominent. So the kid, the 14-year-old, is resourceful and looks at the mail and sees that there is a trust statement from City National Bank
It's not a trust, it's a bank statement.
or bank statement, and he opens up the mail, sees the name of the trust.
Or even doesn't see the name of the trust. It's just about the trust for their benefit.
Okay, well, let me just, sees the name of the trust, sees the phone number to Peter, City National Bank, calls up Peter and says, hi, I'm 14 years old. I see that there's a trust in my family. Am I a beneficiary? How much is in it? And when do I get my money? Okay, so Jennifer,
you're going to give me the hard
the
one.
question is this, the question is this enforceable, or what happens? Is the trustee obligated?
Yes. I mean, I think the answer is yes. Now, there's other questions that come into play here that have to do with what's appropriate information to give to that 14-year-old. Should his parents be involved in that conversation? Does he have a property guardian who's also been appointed for him that may be able to field some of those questions? But you can't, I think that all of